our environmental principles. Thank you, sir.
I call the Honourable Ruth Dyson.
Mr Speaker, the member who's just resumed his seat started his contribution by saying that he was going to answer a few of the questions posed by my colleague Moana Meki. He totally ignored every single question that my colleague Moana Meki had asked. But that's not surprising, because the Minister who sat in the chair during the committee stages of the bill did exactly the same thing. The only contribution he made to the House, actually, and I'm talking about the Honourable Simon Bridges, was to be abusive. He was then followed by Honourable Chris Finlayson, who was also abusive. Personally abusive of Sir Geoffrey Palmer and Dame Anne Salmon. Dame Anne Salmon, New Zealander of the Year, was denigrated in this House by our Attorney-General and the Minister responsible for this bill. I thought it was an outrage, and I'm looking forward to a bit more contrite behaviour from both those ministers in the future. I was also surprised by the contribution from Jonathan Young, who actually should know better. He does come from an area where exploration is really relevant. He knows that all the good things that happen in Taranaki that he was boasting about, and I agree with him, they are very good for that region, happen under existing law. The opportunity to have environmental protection and conservation values recognised exist under current law, and this legislation weakens it. Mr Speaker, as has been pointed out, Labor supported this bill going to Select Committee, but said we had bottom lines about the role of the Minister of Conservation in making decisions, which should not be weakened, and the importance of protection of our environment and conservation, which again should not be weakened. And if those fundamental issues were not addressed, then we would oppose the legislation. I think it's a shame. I think it's a huge missed opportunity, and it's particularly frustrating because in an area where such a lot of investment is required before there is potential financial return, the best thing that this Parliament can offer to the exploration industry is security. If we could get wide cross-party agreement on important issues such as the regulatory regime, such as the policy framework, then the industry would have a lot more confidence in going into these areas where they need such a lot of investment. The National Party doesn't have a clue about giving important industry confidence in investment in the future. All they want is a narrow opportunity for some of their benefactors to invest in this area. Well, Mr Speaker, it should not be done at the cost of our conservation estate. It should not be done with a risk of environmental damage, and this bill enhances that risk rather than reduces it. Mr Speaker, I am not sure if the Minister of Conservation is going to take a call in this debate, but I am frustrated that a minister who has such a good record for a National Party minister in the area of conservation is about to have so much of his advocacy and decision-making ability weakened by this legislation, and I think Nick Smith would resent it. I want to briefly congratulate the Minister, though. Over the weekend he made one of the best announcements I've ever heard, and that is the signing off, from his perspective, of the Akaroa Marine Reserve, the Dan Rogers Marine Reserve, and it's a decision that is celebrated, and I want to sincerely congratulate the Minister for making that decision. It doesn't justify this legislation, though. In fact, it makes it even worse when you've got a Minister of Conservation who clearly understands the issues and the passion. Why on earth would we then want to say, but let these other areas go ahead of it? Let the Minister of Conservation have their decision-making power weakened. That is dumb. It's stupid. It gives exactly the wrong message from the New Zealand Parliament, and I don't think that Nick Smith in his heart of hearts supports it. I guess this legislation was drafted up while he was not in Cabinet, and that might explain some of it. Mr Speaker, there have been a lot of conversations during the earlier stages of the debate about the outrage of Supplementary Order Paper SO 205 that was introduced by Simon Bridges. The Select Committee has put a lot of effort and energy into this legislation, a lot of attempts to get things right as much as possible, and where there was clear disagreements, that was sort of put to one side in an effort to make the legislation workable. There was a reconsideration of the Select Committee as a result of the Pike River inquiry recommendations, and I want to commend Jonathan Young, the Chair, and the officials for the way that they looked at those really difficult issues which came about as a result of a tragedy, and a cross-party work was done very, very well in order to ensure the future safety of our miners, and I think that was a great example of how this Parliament should work together. And then along on his black stallion rides Simon Bridges, throwing abuse to as many people as he can as he goes, trampling over basic democratic rights, and in my view, misrepresenting the Bill of Rights consideration on his SOP. I heard both Simon Bridges and Chris Millicent in the House struggling about the Bill of Rights consideration of that SOP, but I understand that Simon Bridges said on TV just in the last couple of days that the SOP had got a Bill of Rights sign-off. Well, I'd like him to table it. I don't believe it. I don't believe that there would be a Bill of Rights sign-off on that SOP. It's a blatant attack on the right of protesters. It is absolutely selective. Simon Bridges totally lied to the House and the public when he said that it was introduced because of urgent matters of health and safety. If it was about health and safety, it would have applied to everyone in that situation, but it doesn't. It just applies to protesters. So I believe that the public of New Zealand feels totally misled and feels as if the democratic process of Parliament, where any matter other than something which is urgent and critical gets referred to a Select Committee for proper public scrutiny and discussion, none of that has been the case in this area, which fundamentally removes New Zealanders' right to have their say. We value protest in New Zealand. Of course, we don't always like it. We're on the receiving end of protest. Of course, we don't like it. But we should cherish our ability in a healthy democracy to make our views known within a legitimate framework, and that right has been taken away from people with the SOP. Mr Chairman, my colleague Moana Maki talked about why this bill has been pushed through, why is there a need, and her summary is exactly right. The national government has no plan B. If it isn't asset sales or exploration at the cost of conservation and environment, there is nothing. And that is not a proper plan for the security and future of New Zealand. It is not the brighter future that New Zealanders were promised by John Key. All it offers is denigration of the precious environment that we boast about so much internationally. The precious environment that is at the heart of our tourism, is at the heart of our Pure New Zealand campaign, and is at the heart of many values of New Zealanders as well. Why would we risk that, Mr Speaker? Why would we say that those values are no longer important? Why do we have an economic benefit test against something which is values-based? Because if we do that, as we do in this legislation, then our values will always lose. And I don't believe, and I know that a lot of New Zealanders don't believe, that money is more important than our values. I think that's a wrong place to start in terms of a legislative framework. Mr Chairman, we've heard a lot about the bad things in this bill, but there are some good things, and I just want to briefly mention them. The move to enshrine Schedule 4 of the Crown Minerals Act and automatic inclusion of some areas into Schedule 4 is a very good move. I have no confidence at all that in the future the National Party might revert to mining in Schedule 4 land, but certainly the move to automatic inclusion is good. The introduction of the two-tier system of permit management, with the higher, more complex permit applications getting a different level of consideration than the more straightforward ones, I think is a very good thing. The improved coordination between the Crown Minerals permitting regime and the health and safety and environmental legislation is a very good move as well. I wish it was extended to all permits rather than just to Tier 1 activities. So, Mr Speaker, I am disappointed that the fundamental issues weren't resolved so that we could support this legislation. It would be a good message to the industry. I'm outraged at the breach of process by Simon Bridges, and therefore we will strongly be opposing this legislation.
I call the honourable member Catherine Delahunty. Tēnā koe.
Tēnā koe, Mr.